Hi guys, this is Jacob Blizzard again. I'm a board certified criminal law and criminal appeal specialist attorney. I practice in Abilene, Texas and throughout the state of Texas in criminal law and post-conviction writ relief as well as criminal appeals. Today I wanted to talk to you guys about something in the writ of habeas corpus process that you need to be thinking about when you are writing your application and when it comes time to prove your claim, how you're going to go about that. So one of the most common grounds, as you've heard me talk about, is the ineffective assistance of counsel ground. That is where your trial counsel did something in your case or did not do something in your case that they should or should not have done, whichever way it happened to be. So they should have done something. They should have investigated more. They should have called a witness. They should have done some action which would have helped you in your case, but they didn't do that, and therefore they're ineffective. They failed to advise you properly. They advised you wrongly, whatever it was. They did something incorrect. So defense attorneys, for the most part, criminal defense attorneys, care about your case when you are in their care as a trial lawyer. Most defense attorneys really care about their clients. That's not everybody, obviously. They really care about the results for their clients. They really care about the way that the state perceives them, their clients that is, and the outcome for their clients. Oftentimes they seek the best things that they can. Now there are those that are just in it because they have nothing else to do and they can get on a court-appointed list and they can get money and they can go on, but that's not the vast majority. The vast majority are there to do a good service for you. They got into this instead of getting into environmental law or corporate law or something like that. They got into criminal defense because it mattered to them that your case and those like you similarly situated mattered to them. So I say that for this reason, because when you go to file an 1107 application, you file an ineffective assistance of counsel claim, the lawyer that defended you is going to be offended. Always. I say always, maybe 95% of the time, maybe 5% of the time they won't be, but they're going to be offended. They're going to be offended that you have alleged something against them that they feel is unwarranted or unjustified. They did a good job for you in their minds. They did the best they could with the bad facts or the bad law or the bad county or the bad prosecutor or the bad judge. Whatever it is, they want to say that is the problem, right? Because internally, we don't like to reflect poorly upon ourselves. So when somebody files an ineffective assistance of counsel claim against you as a criminal defense attorney, it offends you. You're upset. You cared about that person. And now, as a criminal defense attorney, you just think that person's just doing whatever they need to do to try to get out of jail. And I did the best they can. They just need to deal with it or whatever. So when you are filing an ineffective assistance of counsel claim, it can serve you well if you can have a way to reach out to that attorney prior to filing the ineffective assistance of counsel claim in your application. You can have it prepared, and oftentimes this is what we do here, is we will have an application prepared, and we will reach out to the defense attorney that was on the case and we'll say, hey, here's what we've got. Here's what we're looking at. We think that you were ineffective in this particular case. We know you tried your best. You did a really good job on a lot of things, but you just happen to be legally ineffective in this particular situation. Because no one wants to cooperate with you if you call them and you say, oh, well, you just did terrible on everything you did. And we know you just did it for the money, and you're just on the side of the state, or you're in the judge's pocket, or whatever it is, right? No one wants to hear that. They want to hear, they did a good job, they did the best they could, but they may have made a few mistakes here and there. While not that serious, really are actually legally serious and are actually keeping the client in jail. And so we've had success here talking with people about other criminal defense attorneys and just saying, hey, that concept of why you got into defending these people because you care about them, you care about their case. I know that it seems like this is about you now, but it's really not. It's about getting justice for this person. It's about getting a wrong righted in this system. And sometimes you can pull a defense attorney onto your side and you can say, hey, aren't you on team Bob or John or Michael or whoever it is? Aren't you on that team still? And don't you want him to see justice and to get the right result in his case? And the defense attorney, if you can talk with them and you can get them persuaded in that degree, they can be an advocate for you. They can assist you, and you can assist them in preparing the application and the affidavit, and going into court and testifying and saying, yeah, you know what, I do think this was ineffective of what I did. Many attorneys are worried that they're going to get sanctioned by the bar or something for ineffective assistance of counsel. It's not something that happens, but that there are many attorneys that fear it. In any case, if you have a way of you or your loved one being able to reach out to the previous attorney in the case once you've got your application prepared and try to caress that relationship rather than bend or break that relationship, that can really be beneficial for you. If you can get them to talk to you, and they can be an advocate on your post-conviction writ team. That's all I have for today. Just something to think about in the preparation of your application. If you have questions, comment below, and I'll be happy to get back with you. Thanks.